Good afternoon, and thank you for joining us for the first edition in our 2019 series of webinars focusing on biosimilars. This year, we're going to build on the webinar series from last year and look in more depth at some of the burning issues in biosimilars. Today, we're going to focus on patent settlements and antitrust security. My name is Matthew Royal. I will be giving the European perspective today. And I'm joined by Heather Schneider and Tara Themi from Wilkie Farr Gallagher, who will be addressing issues from a US perspective. So there's been lots of activity on biosimilars in recent months and years on both sides of the Atlantic. And this has led to litigation and, in many cases, to settlement of those disputes. We propose in this webinar to explore the market dynamics of biosimilars and the relevant considerations from an antitrust perspective, which may impact on the settlement agreements in particular. We will then go on to use adalimumab as an example. We can't know, obviously, the reasons for settlement, but what we can do is look at what was happening in the US and Europe at the time of settlement and identify what the possible drivers for that settlement might have been. So to start off with, I will hand over to Heather to pick up the story on the market landscape for biosimilars.
Thank you very much, Matt. And we're really happy to join you all for our new 2019 series of webinars. And I think that, before we just delve into some of the details and issues surrounding settlements, it's useful for us all to take a step back and think a little bit about the biosimilar market landscape. And as we've talked about in our webinars to date, and will certainly continue throughout the year, there's a big difference right now between the US and Europe. And so this chart lists the biosimilars that have been approved in the United States to date. It's a chart we're constantly working to update. I believe it's updated as of today. And there's 7 biosimilars on the market. But in the United States, one of the things you'll notice, so this chart lists biosimilar approvals, and the items in bold are actually on the market based on publicly available information. And even though there have been multiple products approved, they only relate to 4 different reference products. And some of them are some of the older biologics that had been on the market, like filgrastim, infliximab, EPO, pegfilgrastim, etc. Now, in Europe, the picture looks a lot different. This is a table, and I'm sure by next quarter we won't even be able to fit this table on a slide, of the approvals, biosimilars approved by the EMA in Europe. And this is current through the end of December 2018.
Current through today.
Oh, it's current through today. And again, it's something that's always changing. We're always looking for up-to-date information. But even looking at this particular snapshot in time, you can see that there are over 30 products that are on the market that correspond to about 15 different reference products. And we've talked about this in our biosimilar webinars last year as well. The market is more mature in Europe. The regulatory framework is more mature in Europe. It's just things have started there before they started here in the United States. And so there's a lot more that's happened in Europe. Now, here's a slightly different take on some of the same data, just to make it a little bit easier to see the comparison. And this is a list of some of the biosimilars, just indicating whether they're available in Europe or in the United States. Adalimumab being the one that we'll use as a case study today, being available in Europe, not in the United States. A variety of, a dozen or so that are in the list here that have check marks for Europe are not yet on the market in the United States. And that difference between the 2 market segments will come into play in the settlement context, as we'll talk about. So I'm going to kick off this discussion by just talking about the legal framework for antitrust scrutiny of settlements in the United States. Now, just to get us all on the same page, many of you on the call might be familiar with some of the antitrust law surrounding settlements in the prior HatchWaxman context. And as many of you may be aware, sometimes these settlements of these cases are referred to as reverse payment settlements. The idea being that in a quote-unquote normal patent case over a cell phone or something, the accused infringer ends up paying money to the patent holder. What had occurred in the pharmaceutical context, where you don't have a generic on the market yet, is that sometimes the brand name manufacturer or patent holder was making a payment to the generic manufacturer, the accused infringement, allegedly in exchange for delayed market entry. And there was a lot of case law on this topic, and it percolated in the United States for a very long time throughout the different circuit courts, and culminated in a Supreme Court of the United States decision that came out in 2013. 5 years ago now. I have to say I thought it was more recent than that, but we've got a lot of jurisprudence that's followed on from this case that we'll talk about. So in FTC versus Abbvies, the Supreme Court held that reverse payments must be analyzed under what's called the rule of reason. And as some of you who are familiar with antitrust know, some things are just per se illegal. The classic being price fixing. If my colleague Tara and I, or my competitor, I should say Tara and I, agree on a price, that's just illegal per se. You don't delve any further into the, effects of that agreement. But a lot of things in antitrust law are evaluated under what's called the rule of reason, which is a very fact-intensive inquiry. And it involves actually figuring out what the anti-competitive effects of a behavior might be, what the pro-competitive effects and justifications are, and basically balancing them. And so, of course, if you're in a litigation, from a U.S. perspective, what this means is a lot of discovery, a lot of facts, very little chance of getting rid of something on a motion to dismiss or summary judgment. As soon as you hear rule of reason, that's what you've got to be thinking. So the Supreme Court said, look, in order to think about these anti-competitive effects, we're going to look at the size of the payment, the scale of the payment in relation to the payer's anticipated litigation costs, the independence of the payment from other services for which it might represent a payment, and the presence or absence of any other convincing justification. Now, how has this standard started to play out? Again, there's a lot of case law in this area that's come out since this decision 5 years ago. The first question is, well, what is a payment? Money could be a payment, although if the money is for a different service or not a payment to stay off the market, it might not count, but money is your kind of most obvious form of payment. A license to an unrelated product, maybe a payment. We put a cite here of a case that found it was, and a cite here of a case that found it wasn't, but basically if it's something of value, it might be considered a payment. An agreement not to launch an authorized generic. For those of you familiar with the Hatch-Waxman context, you may be aware that a generic drug, the first generic on the market, might have had a period of 180-day exclusivity. And sometimes the patent holder would launch its own authorized generic during that period, a generic, so to speak, that came under the patent holder's NDA. And that could be on the market at the same time the generic manufacturer had its alleged 180-day exclusivity. So sometimes as a settlement, the brand name manufacturer might say, I'll keep my authorized generic off the market during that 180 days. That could be considered a payment because it is something of value. A distribution or manufacturing agreement, that may be an agreement that, for example, I'll let you, proposed generic company, manufacture my authorized generic. That could be considered a thing of value that's a payment. Compromising on a damages claim or appeal. We put a case cite here. There's a very fact-specific analogy. Sometimes agreeing to drop all challenges can be pro-competitive. Again, this goes back to the rule of reason. You look at everything. Settling a different case could be considered a payment. Basically, anything of value could be a payment if it induces a generic manufacturer to abandon its patent challenge. And one of the cases that my colleague Tara is going to talk about later when we get into the adalimumab case study is an antitrust case that was just filed on Monday here in the United States, alleging that the adalimumab settlements that have been entered into are anti-competitive because they engaged in sort of a market division between the U.S. and Europe. Now, once you have some kind of payment that took place for a settlement, you also have to figure out if it's large, right? And what does it mean to be large? And without getting into a lot of details here, one of the threshold issues will be, well, how does it compare to your litigation costs? that's at least potentially kind of a safe harbor. We should be able to settle a litigation to, get rid of our litigation costs. And one thing that will be interesting in the biosimilar world is that I think the costs of litigation could be a lot higher. You have a lot more patents involved, and you have a lot of pre-litigation patent portfolio vetting and freedom to operate analyses, all the patent dance stuff that takes a lot of time and money and happens before the litigation even starts. So it'll be interesting to see if there end up being payments in any biosimilar settlements, whether or not the litigation costs end up being higher than in the HatchWaxman context. And then one thing to keep in mind, we can't forget that at the end of the day, even if there's a payment and it's large, you're still trying to figure out, has there been an antitrust injury? And that's the question you always ask under the rule of reason. And it's a common saying in antitrust law that antitrust is about harm to competition, not competitors. You have to show that the competitive process as a whole was harmed. Now, as we've discussed, many of you are familiar with the fact that under the HatchWaxman Act, settlements of sort of paragraph 4 litigation needed to be reported to the FTC and the DOJ, the regulators in the U.S., and there's been a law that was recently enacted in the United States that also requires settlement agreements in certain circumstances in the biosimilar context to be submitted to the FTC and DOJ. And we put the bullet points of the law here itself, but basically it's if your agreement covers the manufacturing, marketing, or sale of the branded product, the biosimilar product, or relates to the 1-year commercial marketing exclusivity for interchangeable products. But what's interesting, and this is noted in the very last line here, is that this requirement is triggered only where the biosimilar applicant provides a 3B statement as part of that patent dance that we've talked about in previous webinars. And as Tara will talk about later, sometimes cases have been settling when they haven't actually, made their way into litigation and maybe not even into the patent dance. And so they might not have to be reported, although typically in U.S. antitrust law, even if something doesn't have to be reported, it doesn't mean it's immune from antitrust scrutiny. It just means you don't have to affirmatively give it to the U.S. agencies. And with that being said, before I hand control to Matt, I want to let all of you who are looking for U.S. CLE credit to let you know this code. This is the code for CLE credit, WFG 1345. That's WFG 1345. And there's going to be a CLE form in the resource box on the website. Matt, I'll let you take it from there.
Thanks, Heather. So let's turn to Europe now. What is the scope of competition scrutiny in Europe, in particular relating to settlements? Now, really, to answer this question, we need to start more than a decade ago with the pharmaceutical sector inquiry brought by the European Commission. Now, it related to generic originator interaction, and the scope of the inquiry was described in the report as follows. Given the importance of a well-functioning pharmaceutical sector and the presence of certain indications that competition in the pharmaceutical market in the EU might not be working well, the Commission launched a sector inquiry into pharmaceuticals in 2008. In particular, the inquiry sought to examine the reasons for observed delays in entry of generic medicines to the market and the apparent decline in innovation as measured by the number of new medicines coming to the market. And the inquiry concentrates on those practices which companies may use to block or delay generic competition, as well as block or delay development of competing originator products. And the primary focus is the competitive relationship between originator and generic companies. Now, in its final report, which was published in 2009, the Commission identified a number of categories of settlement agreements, and those are set out on the slide. And the first category A are settlement agreements that don't actually have within them any limitation on a generic entrant to the market. Category B1 are settlements that have a limitation, but there is no transfer of value from the originator to the generic company. The problematic settlement agreements and the ones that are likely to attract the highest degree of antitrust scrutiny are category B2. And these are the agreements that include a limitation on generic entry and also have a value transfer from the originator to the generic company. Now, these are the reverse payment settlements that Heather has already talked about. And these, what the Commission sought to do was to categorise the settlements that it was told about by the companies that responded to its survey and put them into the different categories. There was the initial report in 2009, and there have been 8 subsequent annual reports that have looked into the settlement agreements that have been entered into. And the latest one was published in January last year. So this is a slide that sets out the data that have come out of that inquiry. The problematic agreements are in red on the right-hand side, the B2 agreements, and they are subject to increased scrutiny. Now, I think the Commission sees the inquiry as a success because the original 22% of problematic agreements has reduced by more than half and is currently sort of running at sort of 10% or thereabouts for the last few years. But in order to get that achievement, to achieve that success, the Commission has led and got into a number of enforcement procedures against companies that have entered into these category B2 settlements. And so the enforcement actions are based on the authority being able to show that the agreement has an impact on competition, either as its object or as its effect. It's important to say that part of this analysis will be a consideration of the patent landscape. Agreeing not to launch in the face of a basic patent or an SPC, for instance, is very different to agreeing not to launch in the face of a weak secondary patent. The common themes in the 3 examples that are set out on the slide is actually the weakness of the patents that are covered in those agreements. So starting with Lundbeck, which related to a drug called citalopram, there were only a few blocking patents that could not be avoided and so had to be litigated. And in this case, the key patent was a crystallization patent, which was very broad because any amount of crystallization during the manufacturing process would lead to infringement. Now, litigation against a company called Legap in the UK revolved around whether or not there was any crystallization in Legap's process. The expert evidence that was adduced on both sides following an inspection of Legap's process suggested that there wasn't any crystallization. But Lundbeck's response to this was to argue that the process was not economically viable, and so Legap must have forged the batch data that formed part of the inspection process. Now, on the first day of trial, the judge made some fairly unhelpful comments about Lundbeck's case, and subsequently Lundbeck settled fairly quickly with Legap. Now, this settlement itself wasn't problematic, but Lundbeck had also settled with 4 other companies, and those settlements formed part of the investigation, and the Commission concluded that those agreements had as their object to distort competition. The next case is the Servier case, which related to perindopril. Now, at Servier's own admission, many of its patents had 0 inventive step, which isn't a promising starting point for a patentee. Once again, only a few patents were actually litigated, and only one, which covered again a crystalline form, the alpha crystalline form, was the subject of a judgment in which the patent itself was described as the sort of patent that gives the patent system a bad name. And although clearly the Servier had proceeded to litigate this patent, it had also settled with 5 other companies. and those agreements were such that those companies were paid not to stay, paid not to launch. And the Commission found again that those distorted competition, but not only this time as their object, but also as their effect. And finally, the example of paroxetine, which is a GSK. And again, there was one key patent. Again, it was a crystal form patent, an anhydrate. Now, GSK obtained injunctions against a number of generic manufacturers, but also settled and paid money for them not to launch. And again, this time the UK Competition Authority found that this distorted competition, both in terms of the object and the effect. Now, obviously, these decisions are all in the generic space, but it's relevant in this presentation to ask, does that have any relevance to biosimilars? And the short answer is yes. The same criteria are likely to apply to biosimilars. And we can get this from a number of different sources. Now, in January this year, the Commission prepared a report to the Council and European Parliament, which expressly says that effective competition from generics and more recently biosimilars typically represents a vital source of price competition on pharmaceutical markets. That same report notes the pay for delay decisions that I've just talked about, and also highlights the possibility for anti-competitive effects of mergers. And in relation to the merger decisions, they noted in the Pfizer-Hospira case that the Commission was concerned that merger would do away with one of the two parallel projects to develop competing biosimilars. The merger went ahead only after the companies had given assurances that pipeline products would be transferred to a new operator and would not simply be dropped. The biosimilars were also specifically addressed in a report by the French Competition Authority, and they identified two possible problems that might affect biosimilars in particular. The first is denigration, and the report from the French authorities says that various health stakeholders remain vigilant to ensure that obstacles to generics are not transposed to biosimilars. Would this be the case, for example, of possible strategies to denigrate biosimilars? And so that is something that the French authorities will be looking out for, and no doubt other competition authorities as well. And then in relation to pay for delay, which we talked about, the report says that if a pharmaceutical company implements a strategy to delay or prevent the entry into market of a biological medicinal product similar to one of their biological medicinal products whose patents have expired, the competition authority will be aware of such practices. So again, it highlights specifically that pay for delay is going to be scrutinized for biosimilars as well as for generics. Now with that, I will hand over to Tara to pick up the story of adalimumab.
Okay, thanks, Matt. So now that we've covered sort of the relevant background and legal landscape, we thought it would be useful to look specifically at one product, adalimumab, and see how some of these principles have played out. Now, here we have a table of the adalimumab biosimilars in the United States, along with their licensure date, if there is one, a settlement date where there is one, and the publicly available information about the U.S. market entry date, if there is one. And to date, 8 biosimilar manufacturers have settled with Abbvie and have obtained market entry dates in 2023. The first to settle with Abbvie was Amgen, and that was in September of 2017. Now, at that time, Amgen and Abbvie were in the midst of litigation, but at the time of settlement, there wasn't really any dispositive decision or anything that in the litigation that looked like it triggered the settlement. And the next settlement actually came with Samsung about 7 months later in April 2018. Now, what's interesting here is that Samsung, at the point at which it settled, hadn't actually submitted its biosimilar application to the FDA. Samsung actually submitted their BLA application in July 2018, according to their company press releases. And that's actually the first in a trend we've seen with the remaining settlements, where the BPCIA patent dance and litigation are completely circumvented by a settlement really early on in the regulatory process. So for Mylan, Fresenius, Momenta, Pfizer, and Coherus, all of these companies appear to have partially or completely avoided U.S. litigation with their settlements. Now, even Sandoz here, Abbvie filed a complaint against Sandoz in August 2018, but that case was dismissed after Sandoz and Abbvie settled about 2 months later. So even Sandoz, even though presumably they went through the patent dance and the beginnings of litigation, they did circumvent quite a bit of the U.S. litigation involving their biosimilar product. Now, when settling in the biosimilars context, it's important to go back to first principles on some of the provisions that you typically see in a settlement, for example, in the HatchWaxman context, because some of these common provisions can lead to unexpected pitfalls when you're looking at a biosimilar. So, for example, you'll typically see what's called a no-challenge clause in HatchWaxman settlement agreements. This clause typically contains language affirming the validity and enforceability of a patent. In the biosimilar context, though, settling parties need to be careful because, unlike in the Hatch-Waxman context, biosimilar-related patents can relate to more than one product. We've seen this, for example, with protein buffer patents. Some of these patents may apply to more than one biosimilar. So any company looking at these sort of no-challenge clauses should consider carefully any provision that affirms the validity or enforceability of a patent that's not specific to the protein you're settling on. And we've actually seen some evidence, however, that biosimilar settling parties have included these types of statements in their settlements. For adalimumab specifically, Abbvie has stated in its publicly available litigation documents with Boehringer that Amgen, Mylan, and Samsung have expressly acknowledged the validity of Abbvie's patents. Now, we don't have any information as to whether that statement applied to specific patents or all of Abbvie's patent portfolio related to Humira. We just don't know that. But the take-home point is that it's important to consider your future biosimilar plans when agreeing to these types of no-challenge provisions. Another typical clause you'll see in a settlement in the Hatch-Waxman context is what's called an acceleration clause. Now, an acceleration clause basically allows the settling party to enter the market sooner if the patents at issue are invalidated by another party, or sometimes more generally if another party enters the market. Here, the Abbvie press releases have actually made clear that the settlement agreements do not allow for accelerated entry based on the market entry of any other settling party. But the press releases are actually silent as to a market entrant that is not a settling party, such as potentially here, Boehringer. And we've just included a few other considerations that anyone looking at a biosimilar settlement should keep in mind, including potential carve-ups or design arounds. Another key issue to keep in mind in the context of biosimilar settlements is the likelihood that these agreements are going to face some antitrust scrutiny. In the United States, these Humira settlements have actually faced some pushback from U.S. lawmakers. So here you can see a quote from Senators Klobuchar and Grassley that was sent to the FTC shortly after the Samsung settlement, but before the other settlements with Mylan, Fresenius, Sandoz, Momenta, Pfizer, Coherus. And this letter requests that the FTC scrutinize the adalimumab settlements, noting that while such terms in patent settlement agreements may not always be inappropriate, the incentives for parties to delay biosimilar entry are present, and biologic markets could be susceptible to patent settlement abuse. Now, there could be any number of reasons, valid reasons, for the difference in marketing dates that these senators are complaining about, including the scope of the patent protection available in the U.S. and Europe, regulatory differences, and things like that. And we aren't providing any comments or analysis on the weakness or strengths of any antitrust claims. The point here is really just that these settlements are attracting a lot of attention. And Abbvie has actually been defending the proprietary, has actually been defending their settlements. In an earnings call after the Samsung settlement, Abbvie CEO Richard Gonzalez stated that based on the strength of Abbvie's patent portfolio, the settlements have a fairly negotiated entry date in the United States. Now, some of the identified Abbvie patents covering Humira, or allegedly covering Humira, have terms extending out to 2033. So an entry date in the United States of 2023 is certainly well before the last patent expiry. So he may have a point here. Mr. Gonzalez also stated that none of the Humira settlements include any sort of payment from Abbvie to a biosimilar. Now, it's possible that, as Heather discussed earlier, the payment is sort of a loaded term in the antitrust space. Although there may not be an actual monetary exchange, there could still be some exchange of value that's not being referenced here. We just don't have any publicly available information on that point. Now, we've talked a lot today about the parties settling with Abbvie, but there is one interesting antitrust issue involving the one party so far that hasn't settled, Boehringer. Boehringer continues to litigate in the District of Delaware. And one thing that is particularly interesting is that Boehringer has actually publicly stated that it's withdrawing its EMA application and is instead choosing to focus on its U.S. products. A Boehringer spokesperson was quoted as stating to the Center for Biosimilars that, quote, "Our focus is on bringing Siltezo to the U.S. market, and we are committed to making it available to U.S. patients as soon as possible, and certainly before 2023. In the Boehringer suit, Boehringer has actually raised a really interesting counterclaim based on the doctrine of unclean hands. And Boehringer is effectively arguing that Abbvie has engaged in a, quote, pattern of pursuing numerous overlapping and non-inventive patents for the purpose of developing a patent thicket using the patenting process itself as a means to seek to delay competition. Boehringer argues that this, quote, global effort to improperly delay competition with respect to adalimumab, end quote, renders Abbvie's Humira patent effectively unenforceable. And this is somewhat of a novel argument. And the legal sufficiency of Boehringer's argument hasn't really been tested yet. But the district court has allowed discovery to go forward on this issue. So it'll be really interesting to see how these claims develop. And as Heather mentioned earlier, there's actually a new class action lawsuit filed against Abbvie on Monday that's asserting sort of similar claims. The class action lawsuit basically accuses all of the settling parties, with the exception of Coherus, with quote, unlawful market division arrangements, end quote, under the Sherman Act. The complaint also accuses Abbvie specifically of creating an unlawful patent thicket that effectively bars market entry. And then the complaint also contains exceptionally numerous state law claims of very similar types of things. So I think anyone looking to settle a biosimilar case in the United States should be watching this case very carefully because it could have pretty significant impacts going forward. And with that, I will hand things back off to Matt for the European perspective.
Thanks, Tara. So this is a very similar table to the one that Tara showed earlier on in relation to the adalimumab biosimilar settlements, this time in Europe. And they correspond to effectively the US settlements that Tara has discussed. I think there are two things to note. The first is, as Tara has discussed, the fact that Boehringer has decided to withdraw its license from Europe and focus on the US. And the second is just sort of probably one of form rather than substance. Mylan's settlement with Abbvie expressly excluded Europe. However, as you'll see in the fourth point down on the slide, Mylan is included in this European table, and that is as a result of taking a sub-license to FKB's license that it had agreed subsequently with, or previously, with Abbvie. Now, the key difference in this table and the US agreement that Tara went through is the launch date. Now, in Europe, the SPC covering adalimumab expired on the 16th of October 2018, which, as you'll see from the table, is the date included for EU market entry. And so, in effect, these agreements don't really restrict the entry of adalimumab competition onto the market in Europe. So I'm now going to spend a few minutes looking at the possible drivers for settlements around Europe on adalimumab. So the Gillette defence is sort of something that needs a few bits of explanation. This is the most active litigation in the UK. Now, FKB brought a so-called Arrow declaration in relation to the use of adalimumab to treat RA and to treat psoriasis. Samsung also joined in these proceedings later on. Now, Arrow declarations are relatively unusual, and they do stem from this concept of the Gillette defence. And this provides a defence to infringement if you are carrying out the prior art or an obvious modification of it. The argument is that either there is no infringement or the patent is invalid. The patentee is caught on the horns of a dilemma. So the concept was originally used more than a decade ago in Arrow and Merck. Arrow revoked a patent in the UK covering a weekly dosing regimen for alendronate to treat osteoporosis. But having revoked that patent in the UK, there were still pending applications in the EPO that covered substantially the same subject matter and which could not be challenged until grant. Now, Arrow sought a declaration that its product, which included the weekly dosing regimen, was obvious. The declaration was challenged by Merck, and who sought to strike it out. It was allowed to proceed through to trial, but then Merck de-designated the UK from those pending applications, and the case settled. So fast forward 10 years, and FKB was faced with an extensive patent portfolio protecting adalimumab. Many of those patents were pending applications and so couldn't be challenged in the usual way in the national courts. So FKB used the concept of arrow declarations to bring proceedings, and as I said earlier, Samsung followed suit. So the cases survived a strikeout application by Abbvie, in which Abbvie argued that the declarations essentially raised invalidity of pending applications and that such an action was excluded by Section 74 of the Patents Act. The jurisdiction to decide arrow declarations was confirmed first by the High Court and then in joint appeals in the Court of Appeal. And so everything proceeded to trial. But Abbvie's response to its failure to get a strikeout was to de-designate the UK from the patents in question and to offer undertakings to the court that it would not obtain a UK patent covering the relevant indications. So the factual scenario at trial was therefore somewhat different to the factual scenario as it existed at the time of strikeout. So this proceeded to trial, and the judgment was handed down, and the declarations granted on what were described as highly unusual facts. So in order to consider whether or not to grant an arrow declaration, the court considered the 3 points on the slide: justice to the claimant and the defendant, whether there was a useful purpose or not, and any other special reasons. Now, the key to the decision was the useful purpose. So the UK court will contemplate granting declarations, but only if they're going to serve a useful purpose. And that useful purpose must be in the UK. And in this case, the judge decided that the useful purpose was served by providing greater commercial certainty than the undertakings that had been offered by Abbvie, promotion of potential wider settlement agreements, which was rather prescient of the judge, perhaps in the context of this webinar, and then thirdly, securing the supply chain to allow FKB to supply the UK market. So what the court said was not relevant to the issue of useful purpose was the persuasive nature of any UK judgment in other jurisdictions. It's also worth noting at this stage that other special reasons included, or in fact was pretty much solely, Abbvie's prosecution behaviour. And that in particular was probably what led to the comment about highly unusual facts. Now, the case was appealed, but it was settled, both FKB and Samsung obviously entering into the settlement agreement with Abbvie before the Court of Appeal could issue judgment. And so we await further clarification from the courts on the extent of this jurisdiction. Now, the other thing that was going on in Europe were EPO oppositions. So there are 4 set out on the slide. They are characterized in that each of them has multiple opponents, which shows the interest generated by the adalimumab market. The first 2 actually, Abbvie wrote to the EPO and no longer approved the text of the granted patent, and that means essentially that the patent gets revoked, and so that was part of the prosecution behaviour that the judge criticised on Abbvie's part, and part of it shielding patents from the scrutiny of the courts and the scrutiny of the EPO. So only in the final 2 that are oppositions relating to adalimumab to treat RA and adalimumab to treat Crohn's disease, so 044 and 491 at the bottom of the slide, they continue. Abbvie actually just had a positive opinion or positive decision, the OD, in relation to the Crohn's disease patent. But given the settlements, only 2 of the original 10 opponents remain. And so what does this all mean from the from an anti-competitive or antitrust situation in Europe. Now, the patent prosecution behaviour of Abbvie in de-designating the UK, in removing approval of the text in oppositions and generally shielding its patents from scrutiny was criticised heavily by the judge, who said that Abbvie has abandoned all relevant UK patent protection in order to avoid scrutiny by the UK court and to prolong commercial uncertainty as to the validity of those patents. And we know from those proceedings, because it was mentioned in open court, that a complaint has been made to the competition authorities about Abbvie's behaviour. And that complaint is actually very similar to the complaint that Boehringer and the class action in the US have brought and that Tara explained a few moments ago. We still await the competition authority's decision about whether or not to take action on that case, but one would expect that decision will be coming shortly. So finally, just on settlement agreements in Europe. Now, as I mentioned earlier on, it does look like, at least as far as Europe is concerned, that the settlement agreements do not bar generic entry to the market, certainly not beyond the SPC expiry date in October 2018. And that, to use pharmaceutical sector inquiry speak, is a Category A settlement agreement, which means very likely that is not going to be subject to further scrutiny from the competition authorities. But as I mentioned earlier on, it is clear that there will be scrutiny of biosimilar settlements going forward, and we'll have to see how things develop in the coming years. I'll just hand back to Heather to wrap up.
Thank you, Matt. And we also, as you were talking, had a question from the audience where somebody was wondering, well, if Abbvie lost almost all of their late expiring patents in Europe, why is the settlement effective for Europe? And I think it's an interesting question, the difference in the patent landscapes between the two. I don't know if every patent had expired by 2018 when the products entered, and I also don't know if the settlement agreements might have related to any, future, continuations or anything else that might apply. But I can certainly imagine that part of the defendants' responses in these pending antitrust cases might be that, look, from a business perspective, we want to reach a global settlement in both the U.S. and Europe to provide business certainty for our company, and the entry dates are based on a variety of different things, including the different patent expiry dates in the areas. But I think that all of those facts are part of what makes this such a fact-specific inquiry when you're looking at something under the rule of reason. And one of the questions that might come up is a competitive benefit in one territory, like Europe, enough to offset an alleged anti-competitive harm in another territory? And I think that will be a question that will play out as these cases go forward.
I should say, Heather, just from a European perspective, it isn't that Abbvie has lost all of its late expiring patents. So, as you said, it's very fact specific. Abbvie de-designated the UK, so the UK landscape is very different to the rest of Europe. But there are still, and it was on the EPO opposition slide, there are certainly a number of pending applications still in the system across Europe that expire long after the 2018 entry date that had been agreed by the settlement agreements.
Great, that's useful to know. And I think, and then for our conclusion, what this really all shows is that, first of all, biosimilar development is very active and increasing by the day in both jurisdictions, even though the U.S.'s market is a lot less mature. Patent disputes obviously will be common in the U.S. and Europe, in the patent offices and EPOs and in the courts. And so far, the settlements that we've been looking at, and again, we don't have a really large sample set yet, but we'll keep getting more data as time progresses, have been global with a different entry date in Europe and the U.S. And again, there might be a variety of reasons for that. But antitrust scrutiny of these settlements and scrutiny by, as Tara mentioned, potential U.S. presidential candidates and other people like that are already starting to occur. So it's something that we'll all be watching closely. So that's going to end our presentation for today. Again, those of you who want U.S. CLE, there's an attorney affirmation form in the resource box on the website. The code is WF&G 1345. And there's a pop-up box that either has already come up or will come up when the webinar leaves that has a survey. And we would appreciate if all of you would take that. We'd really appreciate any feedback or ideas for future seminars. And for those of you seeking CLE credit, it's particularly helpful for you to do that. All right, thank you, everyone, and we'll see you next quarter.